1948, Shelley v. Kramer. The Supreme Court found that while racially based restrictive covenants are not themselves unconstitutional, enforcement of the covenants is. Private parties may voluntarily adhere to the racially based restrictive covenant. State enforcement of racially based restrictive covenants, however, is discriminatory as it violates the Equal Protection Clause of the 14th Amendment, challenging racially based covenants. A black family by the name of Shelley purchased a home in St. Louis, Missouri in 1945 without knowing that there was a racially restrictive covenant on the property. The covenant had been in place since 1911 and barred people of the Negro or Mongolian race from owning the property. Residents of the neighborhood sued to block the Shelley family from taking possession of the property. With the Shelley decision, the Supreme Court ruled that private agreements to exclude persons of designated race or color from the use or occupancy of real estate for residential purposes do not violate the 14th Amendment, but it is violative of the Equal Protection Clause of the 14th Amendment for state courts to enforce them. Essentially, the court found that racially based restrictive covenants are not themselves unconstitutional. Private parties may voluntarily adhere to them, but state enforcement of such covenants, including judicial enforcement, would be discriminatory, and therefore violate the Equal Protection Clause of the 14th Amendment. Despite the ruling of the court, the widespread practice of racial covenants continued, although it was now legally unenforceable. Recap. The Shelley family bought a house that came with a restrictive covenant placed on the property in 1911. The family was African American and was unaware of the covenant when they purchased the house. The covenant restricted Africans and Mongolians from owning the home. 30 of the neighbors sued the Shelleys to try and uphold the covenant restrictions. The Supreme Court of Missouri stated the covenant came with the land and ruled in favor of the plaintiffs. Another similar case was combined with this one to create Shelley versus Kramer and was sent to the U.S. Supreme Court. Vinson held that private parties could abide by the terms of a racially restrictive covenant, but that judicial enforcement of the covenant qualified as a state action and was thus prohibited by the Equal Protection Clause. Supreme Court ruling. Restrictive covenants like the one used here are not invalid, however. Not allowed to use the judicial system to enforce racial discrimination, and it violates the 14th Amendment. Jones v. Mayer in 1968, Joseph Jones, an African American, sued Alfred Mayer Co., a Missouri housing development company, for allegedly refusing to sell him a home in a particular area because of his race. Plaintiffs stated that it violated the Civil Rights Act of 1866. The district court ruled that the Civil Rights Act applied to state actions only and was appealed to the Supreme Court. Supreme Court ruling. The Civil Rights Act of 1866 applied to private citizens as well as actions were taken by the government. The 13th Amendment gave Congress the right to regulate the sale of private property to prevent racial discrimination.